Good evening to everybody. A particular welcome to our friends from the American Court who are here with us this evening. Possibly had we known 3 months ago you were coming, we might have put a bit more transatlantic content into the lecture, but Master Akenhead is going to do his best. Also, welcome to those who are seeing us online. This is, I think, the third in the readers' lectures in this year. And for our visitors from America, I don't know if you're into court, have a reader. Historically, the reader, well, in present terms, the reader is the number 2 in the governance hierarchy. In the good old days, back in medieval times, the job of the reader was to ensure the education of the bar students, which I think largely consisted of them attending moots at a dinner, and which took priority, I don't know. But there was a sort of moot organized by the reader, and the judges present would judge, and no doubt those that lost may have lost more than their reputations, I don't know. So that was what the reader used to do. Happily, these days, we have an education and training committee and various outreach committees that undertake the organization of most of our professional education. But a vestige of it is that the reader is asked to invite 4 people each year to give a lecture, of which this is one. So I'm very pleased to introduce my very old friend in every sense of the word, Master Akenhead, Robert Akenhead, Sir Robert Akenhead, who had a very distinguished career at the construction bar, dealing with building disputes of huge nature. He was for many years head of Aken Chambers, and subsequently that, and to no one's surprise, he was appointed a High Court judge, and again to no one's surprise, he became the head of the Technology and Construction Court. I think that's the right way around. He has now retired, at least in theory, but should you need a stern arbitrator for any of your disputes, he is available anywhere in the world and does a lot of that sort of thing. So I should confess that he and I were at university together, but we have agreed that what happened at university stays at university. But I will acknowledge the huge contributions that Master Akenhead has made to the bar drama, I mean in the proper sense of drama, in terms of theatrical drama in his time. He used to do many productions with the Bar Theatrical Society, and he's done, I think, 2 very spectacularly successful productions for this inn. But we're not asking him to speak about acting tonight, but about the role of experts in our court. So, Master Akenhead, welcome.
Now, many of you have been involved in cases involving experts. I'm probably too loud. Just a little war story from the first expert I ever called as an advocate. This was in about 1903. No, it wasn't. It was about 1974. It was a case about bricks. I did construction work. And what else could you have a case about? And my expert was very good. And in those days, they would produce a report, but they wouldn't have been exchanged beforehand. So the evidence had to be given by the expert in the usual way, led by questions. So what's your view on this? But it got to a little stage, a little advance, in that you could submit the report of the expert as an exhibit. And in the county court, which are the lower level courts, or considered by some to be lower level courts, the judge was a former war hero, and he walked with a limp, nothing wrong with that. He had a silver cane, and he came in, sat down, and I called my expert. And he said, it's my practice to make the expert read the report, in effect, to put it on the record. So I said, well, so be it, Your Honor. And so the expert started reading his 15-page report. And just near the end of it, my solicitor, those who know the English system, tugged at my gown, because we wore gowns and wigs, and was whispering something to me, don't forget to ask him about the weather, or whatever it was. So I just bent my head, the cane came down on the judge's bench, and he said, "Stop!" And I said, "Okay." And he said, "It's clear, Mr. Akenhead, you are not listening to your expert. I'm going to ask him to start again at page 1. I'm glad to say that the English courts have moved a bit further on than that. And systems are in place, so whereby that is not necessary anymore. The report is usually taken as read. So, so over a career of nearly 50 years, and Robert is correct in saying, I say Master Reader is correct in saying that I am older than him, but not by much. And I've come across every type of expert, good, bad, indifferent. If occasionally during this talk there are more memories of the bad ones, that is only because the experiences were more amusing, at least with hindsight. And there's only so much praise that you can make of a good expert. Now, I know a number of you here are involved in international work and also in work in the United States of America. Now, I've never arbitrated in the United States of America, but I have regularly worked with American lawyers and indeed experts, so I know what they're like. If I talk to some extent about the English system, it's not because, for instance, in arbitration, we adopt precisely what is in the English court system about experts, but we generally, in international arbitrations, do follow the main principles of the need for the expert to be independent and to be impartial, albeit retained by one side or the other. So in the UK, there is a rule of court called CPR Part 35. Has a ring about it, don't get too excited. It highlights the overriding duty owed by any expert, which is to the court. Now, this has been going on before these rules came in. Cases such as Whitehouse and Jordan, which I think is a personal injuries or clinical negligence case, the Icarian Reefer, which is a commercial case about a ship, I think, and more recently, by way of example, a case called Imperial Chemical Industries, Merrill, which re-established, reconfirmed the need for the expert to be independent. Now, a Part 35 practice direction specifically states, expert evidence should be the independent product of the expert, uninfluenced by the pressures of litigation. You could put a square bracket and say arbitration there. Experts should assist the court by providing objective, unbiased opinions on matters within their expertise, shouldn't assume the role of an advocate. There are different practices in the different fields of law, which the specialist bars in this country have regard to. There are protocols and guides and applicable in medical or clinical negligence, different provisions in family court proceedings, which are different from those in the technology and construction field in which I specialize. If I haven't mentioned any of your specialities, that's because I don't have time. You'll please know that I'm not going to carry out an arid analysis of the differing procedural requirements so far as expert evidence is concerned, applicable in different areas of law, as time and inclination won't permit. But it's clear that the courts, particularly over the last 5 to 10 years, are taking an increasingly robust line, mostly pre-trial, in relation to the admissibility and other aspects of expert evidence. There's been a fairly recent case in the TCC. I do know about cases that happened outside the TCC, which is called Dana UK Axel and Freudenberg, about 3-4 months ago, which actually excluded expert evidence at the trial when it emerged that there was extensive and non-compliance with a relevant guide. In an excellent judgment, Mrs. Justice Joanna Smith said this: the establishment of a level playing field in cases involving experts requires careful oversight and control on the part of lawyers instructing those experts, all the more so in cases involving experts from other jurisdictions who may not be familiar with the rules that apply in these jurisdictions. For reasons which have not been explained, there has been no such oversight or control over the experts in this case. That was on one side. So the provision of expert evidence, she said, is a matter of permission from the court, not an absolute right, and such permission presupposes compliance in all material respect with the rules. I agree with counsel's submission that the use of experts only works when everyone plays by the same rules. If the rules are flouted, the level playing field abandoned, and the need for transparency ignored, as has occurred in this case, then the fair administration of justice is put directly at risk. Now, those experts were not from the United Kingdom, which doesn't mean to say they're hopeless, but they either weren't made aware of the rules or were aware of the rules and simply deliberately ignored them. And she excluded on day 7 of a trial, it was a 9-day trial, the defendant's expert reports. Now, you might have thought that might have been done before, but it wasn't clear until then that there had been very serious non-compliances, which went to independence and impartiality. Perhaps unsurprisingly, 2 days later, into the 9-day trial, the defendant lost the case. The judgment came out in late July of this year. Obviously, experts need relevant expertise in their chosen fields. That you might have thought was a given. But relevant expertise does not necessarily involve degrees or doctorates or even memberships of relevant institutions. In my early days at the bar, not quite, I moved on from the county court. I was acting for a large firm of London city solicitors who'd employed some contractors to put in mechanical, electrical, air conditioning and the like in their big city offices. And things had gone wrong, and they employed an expert who was phenomenally helpful to me as we prepared the case. And he produced a draft report, which looked very good, but it contained a list of qualifications at the end, some of which I just simply didn't recognize. Nothing wrong with that. But I then asked him what they were, and it emerged that every single one of about 15 qualifications were ones you buy. So we spotted it in time. Everything he was saying was perfectly sensible. And I said, well, what actually is your expertise? And he said, well, all I've got is 40 years in the mechanical and electrical contracting business. Well, will you put that in? That is your expertise. Anyway, because the report was good, it went in, the opposition collapsed, and the case settled. So now there's another case, which is not about an expert, but I must tell you, for animal lovers, it's a very important one. It does involve, some of you may have heard this, a case called B Sky B. A witness for the claimant indicated that he'd obtained a postgraduate MBA degree from a university. And I hope none of you are members of this institution. It's called the Concordia College, St. John, in the American Virgin Islands. And under cross-examination, this witness spoke very highly of the MBA which he'd obtained, and that it had been very hard work. He'd had to fly to the Caribbean for a number of the courses and so on and so forth, and he thought it was a tremendous qualification. So he was cross-examined on the Friday, but there was still a bit of time left for the cross-examination. It started again on Monday. Leading counsel, who was called Mark Howard QC, told the witness that over the weekend, someone called Lulu Howard had obtained an identical MBA from the same institution upon payment of the requisite fee. When put to the witness that Lulu Howard was leading counsel's dog, the witness's credibility was shot. Now, this is absolutely true. This is in the judgment. It's quite a long judgment, and it's the only funny part of the judgment. This Justice Rams is a very old friend of mine. I'm sure he won't mind me saying. But very important to this was, this is the qualification that Lulu got, the printed scroll that Lulu was given. Wagged her tail enormously when she got it. Lulu is conferred the degree, rank, and academic statements of Master of Business Administration with a major in international business as a consequence of our widely reputed degree program and of our guided academic research into various subjects. During her connection with Concordia College and University, we experienced Miss Howard, let's say over the short weekend, as a conscientious and orderly element who proved the habit of timely and correct study and research to be intrinsic to her person. The English wasn't brilliant. Anyway, she successfully completed all requirements of our Board of Examiners within the mutually agreed time limitations. Miss Howard demonstrated that she's prepared and fully equipped to add valuable apprenticeship to our institution's activities by means of talented and profoundly investigated subject treatment. So, great place to get one. Cost you, but perhaps if you're going to be an expert, don't put that one down on the list. So apart from expertise, a key factor is independence and impartiality. Nothing worse than the expert who starts being an advocate for his or her client and is in effect a gun for hire. Over 40 years ago, okay, moving on to High Court work, so things were looking moderately good, we had an initial discussion with clients and solicitors and one expert, an architect expert, eminent. We discussed the case. He hadn't produced a report at that stage. And I asked him what his views were. And he said this: I'll say whatever you want me to say. Now, disastrous. And I didn't, of course, say to his face, well, you're afraid we're not going to have you. It wasn't my choice. I made it clear, obviously, to the solicitors later, well, eminent person, but if actually that is his attitude, it is not good. And so we didn't go with him. We still won the case with someone else, but that's another matter. The expert world is big business now, with large international firms competing for the work. Back in the day, a lot of experts, including medical experts, often came to it towards the end of their careers, almost as a part-time or post-retirement job. That's fine, lots of experience, but there are problems with that in that you can, as an expert, get out of date. And also you're subject to the question, well, when did you last deal with this problem? If you say, well, I think it was about 34 years ago, it doesn't come over so well. So it's a factor to bear in mind. I'm not expressing any ageist tendencies here, because the older they are, the better, as far as I'm concerned. These large conglomerate firms can give rise to other problems, not least of which is conflict. Some of you might have come across a case in the Court of Appeal here called Secretariat, which is a large international organization. Sorry to say, I'm delighted to say that there are many good experts in that firm, and they are primarily USA based, but they have offices around the world. And the problem there was, the issue was the position of different firms within that group acting in two separate live arbitrations involving two existing litigation support and expert retainers, which each client wished to maintain, where what the client was complaining was that the same expert organization would be supporting, advising, and given evidence for and against the same client about the same project and on the same or similar subject matter. Now, you might think it would be pretty obvious that surely there was a conflict, and the courts would find some way to prevent Secretariat acting on one or both of these cases. It's pretty obviously, I would have thought, a conflict. Fortunately, there was a term in the conditions which Secretariat had negotiated with their client, which did talk about there being no conflict of interest. And so the court was able to use that to say, right, well, there clearly is a conflict of interest. The contract says no, and we've got to do something to stop it. But there was an argument about fiduciary duties and whether the relationship between expert and client is akin, given the duties of impartiality and independence, whether there is a fiduciary duty. The Court of Appeal was a bit iffy about that. And if anything, they hinted that they would not be keen on extending the law relating to fiduciary duties. And so you have to watch this space, because these big international firms will introduce terms, if they don't already have them, please don't take notes if you think this is a good idea, which actually expressly legislates for that sort of thing. Necessarily, if the same expert is acting on both sides, then you need some very clear wording. But it may be that that's what's going to happen, and the courts are then going to have to grapple with whether there are any ways to avoid that. Of course, there's a dichotomy, isn't there, in an expert required to be independent and impartial, because they're paid, employed by one side or the other, and the expert owes the contractual duty to the clients to exercise reasonable care and skill, and so on and so forth. So it's a difficult one, and there will be conflicts from time to time, but decent experts should be prepared, as earlier in the case as they're retained, to start indicating if they have very real doubts about their client's case in the area which he or she's been asked to talk about. Of course, there is years ago, again, this is a building case. It involved the Birmingham Dental Hospital, if any of you have had a tooth out there. But on the outside was tiling, cladding. I think it was white, to do with teeth, I don't know, but anyway. And these tiles kept on popping off, and that was because, mostly when you have that arrangement, you have something called a movement joint, which allows movement and prevents them dropping off. We had a man who'd been a former president of the Royal Institute of British Architects as our expert, terribly nice man, and very competent, bright, years and years of experience. He'd written a report which said, yes, the architect in this case had failed to exercise the reasonable care and skill to be expected of a competent architect, in not allowing for movement joints. And so we go into the witness box. I say we go, he goes into the witness box, and my QC, we used to call them QCs in those days, he was asked a question by my reader, eventually, because he had to introduce his evidence, although his report had gone in. Do you consider, Mr. X, that there was any respect in which the defendant in this case failed to exercise the requisite care and skill? There was a long pause. The answer you don't want, well, that's a very difficult question. And eventually, when pressed, because we had to press him, because we needed his answer, he eventually said, well, put like that, no, I don't think. No. So that was the end of the case. We asked for an adjournment, and we got the case settled. There were a few other aspects of the case. And fortunately for the barristers in the case, we settled in time for lunch. Because as you know, particularly to barristers generally, and inner temporal barristers in particular, lunch is very important. So, of course, this could give rise to an architect being sued, even as an expert. And we know there's been House of Lords, as it was, authority, Jones case, that people involved in litigation, including barristers and solicitors, can actually be sued for negligence, and as can experts. So an expert could be sued where he had, wittingly or unwittingly, misled his clients to say that he'd be giving certain evidence, and then had doubts about it, and ditched them, so to speak, in the witness box. Of course, experts can change their minds, but I would have thought their duty must be to tell their client as soon as possible of the change of mind, so the client can do something about it, if possible. So experts need to have the right qualifications. Now, you would have thought that might be obvious. Medical, accounting, engineer, architect, other types of expert giving evidence about professional negligence, often asked whether they have practical experience as in whatever field they're giving evidence about. An example is the Corby Group litigation in 2009, some of which you may have heard about. It involved children born with birth defects arising as a result of pollution occurring during the reclamation of the old British steel site in Corby. Heavy metals being spread about in the air around the town, including to women in the first trimester of pregnancy. So there were lots of cases brought together in group litigation. And one of the areas of expertise required was toxicology. If there were heavy metals, that's toxic. One side, the claimants, called an eminent and experienced toxicologist, and the other side, Corby, called a highly intelligent person who was probably better qualified than the other side, but was not a toxicologist. Unsurprisingly, slightly oddly, counsel for the claimant in that case did not ask the question when she was being cross-examined, are you a toxicologist? But I thought, as the judge in the case, I ought to ask. And she was very honest and said, no, I'm not a toxicologist. The judgment says this, he, that's the claimant, was immeasurably better qualified as a toxicologist. His experience as a pathologist gave him the most useful insight, the effects of toxic substances on the human body. Dr. Searle was not and did not profess to be a toxicologist. I strongly felt that her approach was almost entirely dictated by her examination of published papers. She did not and could not effectively approach the opinions, research, and regulatory approach set out in those papers from a toxicological viewpoint and background. Sometimes experts are overqualified. This is where we start getting into some of the war stories. Some experts are jacks of all trades. So they've got lots of qualifications, and one or more of them might be relevant to the matter in issue, but they've never really done much on any aspect of their qualifications. Fairly early in my career, I was involved for a school, new school, which sued a main contractor, which had built a school. It was to do with a chimney, steel chimney that came up from the basement where the boiler was, all the way through the school. And it was welded at the bottom. Now, I'm not an expert welder, but good welding usually involves welding all the way through the metal, rather than butt welding, which is just sticking a bit of weld around. So you need full depth welding, and that was what was required here. What happened was that after a year or two's use, it was noticed, probably because smoke was getting out in the basement, that it was leaking smoke through the weld, and it then emerged that the welding hadn't been done properly. So it seemed pretty obvious that the cause of failure was inadequate welding. However, the defendant contractor's expert had different theories, listing about 10 possible causes, without identifying what he thought was probably the right one. Now, one of these theories was based on the sinking during the Second World War, and I'm talking about this case, which was about mid-70s, I wasn't around during the war, that a ship called HMS Hood was sunk by the German battlecruiser Bismarck, which one theory went was due to a lucky shell going down the funnel of the ship. I could never understand that theory because there were only 3 survivors, none still alive at the time, and the school was in South London, where it was extremely unlikely that a military shell had gone down the school chimney. It's fair to say that all of his theories were completely bizarre. I tried to be objective at the time, and none of them, not one of his theories, included the inadequate welding. He just ignored that one. Anyway, he was called as a witness in the morning, and after he'd given his introductory evidence, it was 10 to 1. It's getting near the barrister's witching hour, which is lunch. And the arbitrator suggested that we break for lunch. I think I said I had one short topic, and it went something like this. Question. I noticed, Dr. Smith, that on your CV, you have 4 lines of qualifications from a degree, a master's degree, a PhD, memberships of the institutions of civil, structural, electrical, mechanical, nuclear, chemical, building services, and highway engineering, to membership of the RIBA, amongst others. You were obviously highly qualified. And he said, I'm so glad, Mr. Akenhead, that you refer to this. You may not know that I left school. I'm not going to put the Liverpool accent on. You'd be glad to know. Although I was in the Bar Dramatic Society, Theatrical Society. You may know that I left school when I was 15, and having worked in the shipyards on Merseyside until I was 23, I took an external degree at Liverpool University, a Master's in Engineering at Manchester University, and a PhD from Nottingham. Over the last 30 years, I've taken all the exams in all the different institutions, and it's been a really interesting life. Question. I noticed the final qualification is a degree in law. Yes, he said, I found law absolutely fascinating, and I really hope that I'll be able to do your job soon. I bit my tongue at that. I wasn't asking him very clever questions. I notice in your report that you've come up with a wide range of possible theories as to why this chimney got damaged. In all the subjects which you studied when doing the law degree, did you ever study the law of evidence? There was a pause, and he said, funny you should mention that, Mr. Akenhead. No, I didn't. Yes, I answered. I thought that might be the case. Would that be a convenient time to break for lunch? A cheap jibe, but it helps win the case. So thus far we have overqualified, unqualified, falsely qualified, and the expert on the witness stand, who completely goes back on what he or she said in the exchange reports. When I was a judge, seems a long time ago now, I considered it useful in my judgments to summarize my views about the experts in different disciplines. This was to explain to the parties who read the judgment why I preferred the evidence of one expert over another, rather than just a blanket conclusion that I preferred Dr. X over Professor Y. And and a number of judges do that and have done that since. And I think it's a fair thing to do for the parties. Also clears your mind as a judge or an arbitrator. Why am I preferring expert one over expert two? And in a case called Walter Lilly, which some of you may know about, it's a construction case, they have things called delay experts. I'm not going to go into that in great detail, but to try and prove what delay occurred and why during the course of a construction project. So in about the two delay experts, you can tell who I was going to go for. I preferred Mr. R in almost every respect. He broadly, logically, and conventionally adopted the approach of establishing delay in a usual way. Dr. A's report, that was on the other side, also in some respects, read simply as a suggestion to the court that the claimant had not proved its case. An example is the opening words. Walter Lilly's case does not stack up. Now, if you have an expert who writes that in his or her report, the other side's evidence doesn't stack up, it's getting close to rather bad advocacy. And it's something that one wants to encourage one's expert to avoid. And so that's one sort of problem. You can pick out from this some of what experts should or shouldn't do. You've got to be objective, avoid coming down in favor of the client on disputed factual issues. And if there is an issue, there's not a problem for experts. It shouldn't be a problem. And say, well, if the fact A is found, then my view is this. And if it's fact Y, then it's something else. But don't start saying or giving the impression to the judge or the other side that you are commenting and forming a subjective view as to what facts the judge is going to find. Judges probably don't like it very much, although these days they are very polite. I notice there are several judges in the room. I have to say that in case they do me for contempt of court, which I'm sure they won't. There's a case called Obriscon, which was about civil engineering works at Gibraltar Airport. I don't know if you've ever landed there. And a major issue was whether or not lead and hydrocarbon pollutants found in the ground where a tunnel was to be constructed were reasonably foreseeable. Two geotechnical experts, we go into any detail about them, they were both equally good as each other, the judge said, and one then just simply has to decide the case on the merits of the evidence they put forward. And so we have experts of equal ability an experience, that's what you have to do. It's not necessarily a case of saying, well, claimant's expert says this, the respondent's expert says that, defendant's expert says that. I found them both of equal value, therefore the claimant hasn't proved their case. The judge or arbitrator can exercise his or her mind appropriately. But when we came to experts who dealt with what was reasonably foreseeable, whether the contamination was reasonably foreseeable, what I'm recorded as saying is that Mr. W adopted a very blinkered view as to what was foreseeable, particularly ineffectively ignoring the history of the site, although he belatedly made some concessions. He wouldn't answer simple questions. He'd be asked the same question 3 or 4 times and not answer it. And that's usually not a very good sign. Judges simply want to be, and arbitrators want to be helped. They don't try and make up their mind early in the case if they can ever avoid it. And they want to get to the merits of the case. Now, there are too many war stories to tell, but there is one I probably should mention. Returned to Liverpool, a case called National Museums and Galleries versus an architect's firm called AEW. And this related to the new Museum of Liverpool. It was new in 2010 or 11. Those of you who visited it on a sunny day without too much wind will know it's a very pleasant place to stop for lunch. The claimant's expert was considered extremely experienced as an expert and as an architect, and produced the best expert report. He was extremely thoughtful, serious, and knowledgeable. The architect expert was allowed to give his evidence together with an engineer expert. They literally sat on the same witness stand, and although they were asked questions separately, they were there together. And I recorded saying this: I was surprised to say the least, to be told by Mr. W, this is the engineering expert, that he and Mr. P, who was the architect expert, that they'd not been asked to consider what could reasonably be expected of architects in the defendant's position. Rather extraordinary state of affairs in a case all about alleged professional negligence may explain why such little coherent thought had been given by Mr. P to this aspect of the case. And he made a concession under cross-examination, and I'm just repeating what the judgment said, which one would simply never expect a competent expert who was aware of his duties to the court to make. He accepted that he was, listen to this, seeking to defend the indefensible for the benefit of the architect defendant. Now, great if you're a counsel and you can get that answer out of the expert. And it was a very clear question. It wasn't any suggestion that he had misunderstood the question. And unsurprisingly, I said I can place no weight on any of his evidence, save where another expert may have agreed. So we're getting, these are the less good side of expert evidence. Inevitably, lawyers, solicitors, barristers will be involved in the selection of experts. Nothing wrong with that as such, and potential experts will be asked questions identifying what their broad approach on the issues in the given case is. And it's unsurprising because it's a rare case in which a party produces an expert whose evidence is against his or her own client. And once selected, the experts will often play a material part in the pleading of a material case or defense, or the production of memorials in arbitration, not least because parties should plead material facts on which they rely in the case. But there is a dividing line between what the solicitors and barristers should be allowed to do. They shouldn't simply tell the expert, this is what you must put in your expert report. Of course, it's all privileged, it's all behind closed doors, and it's almost impossible. But very occasionally it comes out where an expert has been heard to say, certainly in one arbitration, was that's what I was told to say. Again, collapse of stout party because it undermines the credibility of the party. There is a dividing line which sometimes gets obscured. There's been a very recent case a few weeks ago called Pickett and Balkin in August of this year in the TCC. It related to joint statements. Those of you who don't know, joint statements are common, almost invariable, in cases that two experts meet off the record, produce a joint statement, which they agree to identify what they agree about and what they disagree about. Shouldn't be too complicated. And there's been a habit amongst some for the expert to take his draft back to his side and have a detailed discussion about what needs to be changed. And in this particular case, there was quite clear evidence of that having happened. It arose because it was a nuisance case about tree roots, and an arboriculturalist expert was not able to attend the trial and wrote a letter saying, I'm having an operation, I won't be available at the time of the trial. But also in the letter, he referred to discussions with counsel in the case about the joint statement, identifying several topics. I didn't quite know why it was in the letter anyway, but it was. And one side, the other side who produced the letter almost by mistake, tried to get it an injunction to stop it being used, and well, that failed. The judge refused an injunction, partly on the ground that there appeared to be breaches of the requirements about not getting involved with the drafting of joint statements. So it's a very dangerous thing to do, and one's got to be very careful. By saying that, I don't mean don't get caught, I hasten to say. We come now to technology, not just because I was in the technology court, but as many of you will know, you get a lot of technology coming into the giving of expert evidence. It's easy to have computer runs that tell you all the answer. If the computer says no, then maybe the case goes your way. If the computer says yes, it may not. So years ago, I did a case with a QC for a contractor about alleged defects on a design and build contract for what's called an oil transshipment jetty in the West Indies. And it required a jetty that goes out from the coast quite a long way, and big tankers could come in, offload tanks on shore, and then smaller tankers could come in to take the oil into the American ports, because at that time you could only have 50,000-ton tankers. And this particular jetty could accommodate 250,000-ton tankers, and the contract required that they needed to be held in place in certain marine conditions, such as wind, 30 knots, and currents, and so on and so forth, and waves and the like. The employer, who was suing my clients, poor builder, relied upon a highly qualified Dutch marine engineer expert with a PhD, who, because in a previous life had been a ship's master, was known as captain as opposed to doctor. His surname was Elias. He relied upon hundreds of computer runs to demonstrate that ships of different weights and sizes could not be accommodated safely within the given condition. His English was nearly perfect. My QC's cross-examination started like this: Captain Elias. Now, naughty, because you really should try and pronounce his name correctly. Anyway, he was a senior QC and seemed to get away with it. Maybe he actually thought that was how you pronounced Elias, I don't know. He said, Captain Elias, have you ever heard of the expression garbage in, garbage out? No, said the witness, I've not heard of this expression. Well, perhaps we'll come back to it later. There then followed, this is the good old days when you could cross-examine for days on end, 5 days of cross-examination in which Dr. Elias was taken to each of his computer runs to consider what input there had been. On most of them, it was put to him, and indeed he accepted that he had put in inaccurate input, such that the position would not be nearly as bad as his report had indicated. He was completely honest. At the end of the 5 days, the QC asked him, do you remember, Captain Alias, I asked you whether you knew what the expression garbage in, garbage out meant. You answered that you did not know that expression. Yes, he answered, I do remember. You now know what the expression garbage in, garbage out means. And because he was completely honest, he said, yes, I think I do know now. The case settled within 48 hours. So good. Object lesson is where you're expert, or you as expert rely upon computer workings, make sure that you're not open to that sort of attack. Because they're in court, so to speak, or in arbitration, you're not going to be able to get your computer out, put the input, the correct input in, run the computer and say, oh, there you go. It still shows something not as bad as I thought, but you're not going to be able to do that. It's going to be too late in almost every case. So judges have got to be careful about running software themselves. Although I was head of the technology and construction court, I was not as good as my 10-year-old granddaughter is now at that. And the problem is transparency, because if you do, I can use some of these systems that I come across, you never quite know what the input that there's been, which you haven't checked. And there are often thousands of pieces of input. So I realize probably we've got to try and finish sometime soon. Today? We've got to finish today. It's okay. So be careful about that if you're an arbitrator or a judge. Don't expect the arbitrator or the judge to do it. We've all come across Excel. Even I can work Excel. But often with a big accounting sheet with thousands of pieces of information, you start fiddling around. You don't quite know why it is producing the answer at the bottom. You know, if you have confidence in the Excel system, that it's probably arithmetically correct, but you don't know whether you can rely on the figure or the figures at the end. So you just need to be very careful about that. I'm going to draw matters to a conclusion. There'll be a chance for questions. So experts and practices who engage experts, there can be a minefield. Experts proving not to be properly qualified, expert acting as advocates. Once they're on the witness stand, there's not very much you can do if they're going AWOL and away from the prepared speech. There's not much you can do as counsel. If you jump in and say, I must ask you to stop, that's not really going to help if it's your own witness. So, in fact, you won't really be allowed to do it. So, with experts under the thumbs of their legal and client teams, experts changing their mind, experts occasionally not doing a good professional and independent job. Truth is, of course, that probably the large majority of experts are decent people, the right qualifications, behave independent and impartially. Judges have to decide who's right and who's wrong. But as I said, some of the times when they go wrong, it's more fun to speak about after the event. So I'm going to finish with a joke, which is the only untrue part of my talk this evening. And it relates to the West Country. The shepherd is herding his flock in a remote pasture on moorland, probably Dartmoor, when suddenly a brand new BMW advances out of a dust cloud towards him. The yuppie driver appears to be on holiday, got an Armani suit, Gucci shoes, Ray-Ban sunglasses, and YSL, that's Yves Saint Laurent for those who don't know, tie. He leans out of the window and asks the shepherd, if I tell you exactly how many sheep you have in your flock, will you give me one? The shepherd looked at the man and at his peacefully grazing sheep, spread out over several miles, calmly answered, sure. The yuppie parked his car, whipped out his IBM ThinkPad, connected it to a cell phone, surfed to a NASA page on the internet where he called up a GPS satellite navigation system, scanned the area, opened up a database, an Excel spreadsheet with complex formulas, sent an email on his very smartphone, and after a few minutes received a response. He printed out a 130-page report on his miniaturized printer, which he had at the back of his Range Rover, or BMW was it? And he said to the shepherd, you have exactly 1,586 sheep. That's correct. Take one of the sheep, said the shepherd through pursed lips. He watches the young man select one of the animals and he bundles it into the car. And the shepherd says, if I can tell you exactly what your business is, will you give me back my animal? Okay, why not? Answers the young man. Clearly, you're one of those rich court-type experts, aren't you? That's correct, said the yuppie. But how did you guess that? No guessing required, answers the shepherd. You turned up here, although nobody called you. You want to get paid for an answer I already know. To a question I never asked, and you know nothing about my business. Now give me back my dog. Thank you very much.
Thank you very much indeed, Robert. You kindly already notified us that you will answer questions, or at least you'll listen to the questions anyway, maybe you'll answer. And I will open it up to this room and indeed to those of you watching on the internet, assuming the technology in front of me will work. But let me exercise my privilege of sitting here while people think of questions and ask you what your opinion and or experience is of the use of joint experts in cases. In other words, that the court, in order to save time, usually, that's what it's about, and cost, of course, requires that on some issues or issue, the parties instruct one expert together, and what your experience is of how effective that is, and whether you think it actually does save time.
I think in the right sort of case, it can work very well. The immediate problem you get is often the claimant, right or wrong though the claimant may be in its case, will often have already retained an expert. And so when the judge or the other side come up with the idea, how about a single joint expert, you usually get a bleat from the claimant's expert. Unless it's something that has been raised at a very early stage. So sometimes in the pre-action protocol stage, perhaps before experts have been retained. Because if the claimant's already produced an expert, but then another expert has to be produced, then it's not overall necessarily an enormous saving. There will be some saving inevitably in the cost. And the courts have had to deal with that. I had one case as a judge with a single joint expert, which was really successful. And it was got to early enough, there was no objection from the claimant, and very good joint expert, and both sides had confidence. And funnily enough, I think towards the end of the first day, the case settled. But probably should have settled a bit before then. So there's probably, with a single joint expert, there's probably a high hit rate for settlement, and that is good, and the courts will say that's good. So I think in principle it's a good idea. I haven't come across it in many cases in my area, but Robert, you may have come across it more in your area, where in very big cases involving maybe millions of pounds, claims, damages, or whatever, when judges insist upon a single joint expert. So it tends, I should think, statistically to be used more in the, quote, smaller cases, important to the parties, of course, but ones that where there will be a very clear saving in terms of costs, in terms of proportionate cost spending.
Thank you. Any questions? Yeah. Yes.
Hi. I'll be very careful.
I wonder if you are familiar with the concept of hot tubbing.
Yes.
And yeah, thank you. I asked if you were familiar with the concept of hot tubbing, and if so, what do you think of that?
We've used it.
You should probably explain what that is, since.
Well, I think a lot of people know hot tubbing is simultaneous giving of evidence by more than one witness, usually with experts, can be with witnesses of fact. I think it's a good idea, not in every case, because there are some sort of cases where it doesn't work terribly well. Ones I've found where it has worked very well is on the money. So in construction cases, it might be called a quantity surveyor, accounting, where you don't necessarily get the right answer, but if you can get agreement between them on the way forward, then it can be very useful. And certainly in my area, defects cases can work very well. You go through the defects, and often the two hot tubbing experts don't want to appear to be unreasonable, so they will compromise in front of your eyes sensibly. And I'm quite keen on it, and we use it in arbitration from time to time. I've had one where we had a question of Indonesian law. This was arbitration, where 3 eminent Indonesian law professors were hot tubbed. And apart from the fact they all wanted to speak at the same time, it was really useful because, again, by and large, it emerged. There wasn't an enormous disagreement between them as to what the relevant bits of Indonesian law were. So I'm broadly in favour, but you can't just say in every case. It doesn't. There are some types of expertise, for instance, where, now imagine medical negligence, clinical negligence, where one side's expert is saying the practice adopted was well below the standard to be expected, and the other is saying completely the opposite. It may not work where there is almost a binary difference between them. Yeah, broadly, I'm keen, and it was in the TCC where it was first piloted. So we were used as the dummy run for a lot of these changes, but I'm looking at Master Saw here. So, anyway, yeah.
I must say, the first time it was proposed in my court, I was rather terrified about what was going to happen and what they might be wearing when testifying.
Well, I think you have to make an order that they keep all their clothes on, but no, it can work. It can work very well. But one of the differences in an adversarial system, which you have in the States and we have broadly here, the judge has to take a more, what we call, inquisitorial approach, ask more questions. Obviously, the advocates can ask questions as well. They're not cut out. But you have to know your stuff when you do it. There's no point just asking airy-fairy, what's your view on this? You can ask it, then you say, well, yeah, but you have said here, you have to be able to not cross-examine them, but to pick them up, and then you get better results.
Thank you. I'm on. You mentioned clinical negligence, which is great because we have in our online audience this question, which is this. Expert witnesses are produced to create clarity, says the question. in medical negligence cases, the prevailing law is that a doctor is not considered negligent if one body of doctors considers his mode of cure treatment correct. And I don't know, you may find there are other similar things in other professions. Does this create a very confusing scenario for a judge, especially if the claimants and defendants, expert witnesses, are at odds with one another? In other words, it's about the practice in any given profession, I suppose, and if that's the defense, there's a reasonable body of opinion. How is a judge meant to decide when two eminent people, experts, let's assume they are properly qualified, vehemently disagree with each other on that, without the answer being obviously that the defendant has won?
I think it's difficult. I mean, it's open to the judge to say, okay, this is what's been said, and I prefer the evidence of one. I mean, judges should actually explain why they prefer the evidence of one, where you have that binary issue between the two. Sorry, I'm losing my mic. Where you have that sort of binary difference between them, and I don't think that a court of appeal would or should interfere with that sort of factual finding, but you have to give some logic, and it's always quite difficult, isn't it, to say, well, there is a not insignificant body of opinion which would support, say, a defendant's position rather than the claimant's position. And one needs to try and analyse that with the witnesses and see what they're talking about. Is it just because I had lots of friends who were at St. Thomas's, a hospital here, very famous hospital, and as students, they spent a lot of time in the bar. Nothing wrong with that. You have to analyse with the expert, not how much time they spend in the bar, but where do you get this from? And you can look at, for instance, published papers and get some idea, particularly in the medical side, clinical side, supporting one view or the other. And so you can get an idea. And you can form a view, but just simply to say, I prefer the evidence of X on that issue, I would have thought courts of appeal might be interested in knowing why you, the judge or arbitrator, prefer. It's easier in arbitration, by the way. It's almost impossible to appeal questions of fact. So even if you reached a conclusion that quite a few other arbitrators wouldn't reach, it's almost unchallengeable. So.
Well, thank you. Any other questions in the room? Yes.
Much of the civil litigation in the United States many states have a rule of procedure that allows.
Sorry, you haven't got a microphone, and so our online audience won't hear you.
I say many of the civil cases in the United States are tried in state courts, and their procedures differ. But many state courts have a procedure that allows the judge to appoint the expert. Do you have an experience with that, and what's your opinion about the efficacy of that?
The answer is certainly it's something that often happens or does happen from time to time in arbitration. And there's often a specific power that allows them to do that in the arbitration rules. I'm not sure I can necessarily, I don't know in the medical one, can judges order a medical expert to be appointed? I think in theory it happens, but it very rarely happens because there's obviously an expense associated with it. It can, where both parties have experts already, it can introduce another certain uncertainty. And I remember in one particular, it was an arbitration, and it was to do with delay, where we, the arbitrators, were permitted. You had two complete opposite positions taken by the experts. So we had a feeling that there might be a middle way in this. It wasn't naught or $100 million, whatever the case was about. It's a power station somewhere. So with the parties' agreement, we actually appointed a third one. And funnily enough, but for completely unbelievable reasons, and we didn't try to influence the expert, he came up with something which was exactly in the middle, almost to 50.001%. And we thought, we can't believe that either. So we had to make our minds up. So I think there can be problems, and it very rarely happens here. Does it happen much in the States? Or? Yeah.
So one more question. I think you're getting thirsty. No one else.
This is water. It's not gin.
Question from our online audience, which is this: have you been involved in a case where there were repercussions for an expert witness who, for example, was dishonest or factually incorrect? You've given some examples of witnesses where that appears to be the case. So what should happen to them, or what does happen to them when they act dishonestly?
Technically, just take a witness, it could be an expert, where you are convinced as a judge that the witness has lied, i.e. committed perjury, you can have the papers referred to the crime prosecution service that we have in this country. And if they want to do anything about it, they will. They seem to have other priorities at the moment, but I've never done that. And I never did it as a judge, although there were a few occasions when I was convinced that the witness was lying, because although it was objective, you were deciding a civil case on the balance of probabilities. So, I never did, but I have known several judges who have done over the years, but not many.
Have you ever had a case where you've awarded costs to an expert? In theory, it's allowed, but I'm not sure I've ever seen it happen.
No, I felt like doing it a couple of times, but no. I did once, I'm afraid, order counsel to pay costs of wasted adjournment. He applied for an adjournment on day one of the trial on the grounds that he'd only received the papers on the weekend. That was something which you should never really own up to, because it doesn't help your position. And so I had pity on him, and I said, well, you won't have to start today, but you'll start tomorrow. And we'll start at 10 o'clock to make up a little time. And so off he went, and 10 o'clock he wasn't there, 11 o'clock he wasn't there, 12 o'clock he turned up. He said, "May it please you, my lord." And he started to open his case. I said, "Fine." I said, "Do you have any explanation why you weren't here?" I wasn't angry. I thought, it might have had to go to accident and emergency or wherever. And he said, "Well, I worked till 5 o'clock at night in my hotel room. I then fell asleep and didn't wake up till 11 o'clock." And I said to him, "Well, do you think you should pay for the cost of an occasion by us hanging around for a wasted 2 hours?" He said, "I can't argue against that." So anyway, the case settled.
I think it's very mean, if I may say.
It was the only time, but I did it in a very nice way, I thought. So I hope the person isn't here, but I'm sure he...
All right, well, unless anyone's got a burning question, I think our throats might be burning. So I'm going to call the halt to this. But I'm going to... What Master Akenhead said does bring to mind my own war story, and I will tell it briefly. I had a case where I was bound to win it because I had the world's leading expert on the subject in the case, a household name in his field. And so I was bound to win. And the other side had a sort of expert that, frankly, you could dismiss. He was an expert who always turned up in cases. It didn't matter what the subject was. It was a medical case. He was a doctor, but that was about it. So anyway, he goes into the witness box, and I stand up in all my pomp and say, "Would you be surprised if I told you that Professor, whoever he was, would say that what you're saying is completely wrong about the practice in this field?" To which he said, well, yes, I would actually be quite surprised. Oh, why is that? Well, he said, when I read his report, I was really worried. So I rang up his registrar and I asked him what happened in his hospital. And actually, it's not what's in his report. It's exactly the same as I've just said. So anyway, fortunately, the lunch rescues you from all sorts of came. And I went outside the court, and there's a court outside over the road here where there were a number of pillars outside. And when I was walking past the pillar, there was a psst from behind it. And I looked, and there was the world's leading expert on this subject. And called me over. You should never do this. Obviously, as a barrister, you're meant to have a solicitor with you. But there was no one there. And he said, I just wanted to tell you that I'm afraid what he says is correct. So I said to him, that we've had several meetings which you and never a clue that this happened in your own unit. Yeah. So why did you tell me that? I wanted to help, he said.
Oh, well.
So there we go. That was another case lost. But anyway, thank you.
The only one, Rob.
Thank you very much, Robert, for a fascinating lecture. We've all learned a great deal about experts, which is one of the more troubling subjects that we deal with in litigation. But thank you very much. And as this isn't a dramatic performance, we won't demand an encore.
Haven't got time. Right, then turn this off. Well, Michael, you held yourself. Sorry.
No,